Hi, YouTube. My name's Doug. I'm a licensed Texas attorney, and the purpose of this channel is to review U.S. Supreme Court cases, in particular on constitutional law issues, First, Second, Fourth, and Fifth Amendment, mostly. I should say up front, this is all presented for educational and entertainment purposes. Nothing I say should be construed as legal advice. But I like a lot of you. I've watched some First Amendment auditor videos and some things like that. You hear a lot of cases being quoted by the police and by these auditors in a lot of cases, and there's some really good stuff out there on this. I like John Bryan's civil rights lawyer channel. Jeff Hampton's is a Texas attorney that I think does a good job on the criminal law side. I like Jared on the Guns and Gadgets channel for Second Amendment, primarily Second Amendment videos, and Anthony at the Armed Scholar channel. I think those are entertaining and informative. But what I think I'm going to do differently here is I'm going to actually go through in detail the cases that I'm going to address, usually about a case for each video, and just present to you what is the court actually saying, to give you a sense, rather than tell you the holding of the case, tell you what the case stands for, give you some relevant facts. I want to go do a little bit of a deeper dive and go into the entire opinion that the court issues, and including some dissents and in some cases some concurrence opinions, and so that's the purpose of the case, and I'm really curious what your thoughts are. I'd love to get your comments on each one as we go through them. And again appreciate your stopping by, and hopefully we'll find some stuff to talk about. So I appreciate it. With that, let's go ahead and take a look at a case, the case for the week. Okay, the seminal case in this series of videos has to be Terry v. Ohio. That probably shows up 50 or to 100 to 1 more often than any other case mentioned in the First Amendment auditor videos, and it's definitely a very, very important one in Fourth Amendment law. So Terry v. Ohio, as you can tell by the name, came out of the state of Ohio, came from the Ohio Supreme Court, in 1967. And there were a lot of these important cases that came out of the Supreme Court in the 60s. I'm going to skip over the attorneys and the amici curiae, and we'll start at Mr. Chief Justice Warren delivered the opinion of the court. I think it's important to understand who Earl Warren was. He was a California Republican. He was governor of California from 1943 to 53, and he was appointed by Dwight Eisenhower, Republican president in the 50s, so his credentials, his Republican credentials, were solid. He actually, I just learned this today, he actually was Thomas Dewey's running mate in 1948. Remember the Truman holding up the newspaper, Dewey defeats Truman? He was Dewey's VP candidate in that election. I did not realize that. But don't be mistaken about his Republican credentials. Eisenhower is reported to have said, my two biggest mistakes are still sitting on the Supreme Court, and he meant Earl Warren and William Brennan, who teamed up with Earl Warren in a number of important Supreme Court cases. Earl Warren wrote not only this opinion, he wrote the opinion in Brown v. Board of Education outlawing separate but equal. He wrote the decision in Miranda, probably one of the most well-known Supreme Court cases, the Read 'em Your Rights case. And he wrote the opinion in Loving v. Virginia, which outlawed laws banning interracial marriages by the states. So he definitely had a very progressive bent to him. And it's important to know that he actually wrote the opinion on this, although it is an 8-1 decision. So there was only one dissenting justice on the case. So the facts are a little bit tedious. Let's go ahead and read through all of them just to give a fair presentation of both what Terry and his buddies were doing and what Officer McFadden was observing. So let's just go ahead and read through that. I've highlighted some, what I felt like were some of the important lines in here, but we'll read the whole thing. So this case presents serious questions concerning the role of the Fourth Amendment in the confrontation on the street between the citizen and the policeman investigating serious circumstances. Petitioner Terry was convicted of carrying a concealed weapon and sentenced to the statutorily prescribed term of 1 to 3 years in the penitentiary. Following the denial of a pretrial motion to suppress, the prosecution introduced in evidence 2 revolvers and a number of bullets seized from Terry and a co-defendant, Richard Chilton, by Cleveland Police Detective Martin McFadden. At the hearing on the motion to suppress the evidence, Officer McFadden testified that while he was patrolling in plain clothes in downtown Cleveland at approximately 2:30 in the afternoon on October 31, 1963, his attention was attracted by 2 men, Chilton and Terry, standing on the corner of Huron Road and Euclid Avenue. He had never seen the 2 men before, and he was unable to say precisely what first drew his eye to them. However, he testified that he had been a policeman for 39 years and a detective for 35, and that he had been assigned to patrol this vicinity of downtown Cleveland for shoplifters and pickpockets for 30 years. That's important. This is me talking again. That's important. The courts give a lot of deference to a policeman's experience and what his observations tell him. Back to the case. He explained that he had developed routine habits of observation over the years, and that he would stand and watch people or walk and watch people at many intervals of the day. He added, "Now, in this case, when I looked over, they didn't look right to me at the time." His interest aroused, Officer McFadden took up a post of observation in the entrance to a store 300 to 400 feet away from the 2 men. "I get more purpose to watch them when I see their movements," he testified. He saw one of the men leave the other one and walk southwest on Huron Road, past some stores. The man paused for a moment and looked in a store window, then walked on a short distance, turned around and walked back toward the corner, pausing once again to look in the same store window. He rejoined his companion at the corner, and the 2 conferred briefly. Then the second man went through the same series of motions, strolling down Huron Road, looking in the same window, walking on a short distance, turning back, peering in the store window again, and returning to confer with the first man at the corner. The 2 men repeated this ritual alternately between 5 and 6 times apiece, in all, roughly a dozen trips. At one point, while the 2 were standing together on the corner, a third man approached them and engaged them briefly in conversation. This man then left the 2 others and walked west on Euclid Avenue. Chilton and Terry resumed their measured pacing, peering and conferring. After this had gone on for 10 to 12 minutes, the 2 men walked together, heading west on Euclid Avenue, following the path taken earlier by the third man. By this time, Officer McFadden had become thoroughly suspicious. He testified after observing their elaborately casual and oft-repeated reconnaissance of the store window on Huron Road, he suspected the 2 men of casing a job, a stick-up. Again, that's very important. He didn't just think they were suspicious. He had an actual crime he suspected them of about to be involved in. He suspected the 2 men of casing a job, a stick-up, and that he considered it his duty as a police officer to investigate further. He added that he feared they may have a gun. Again, this is important. He actually feared that they may have a gun. Thus, Officer McFadden followed Chilton and Terry and saw them stop in front of Zucker's store to talk to the same man who had conferred with them earlier on the street corner. Deciding that the situation was ripe for direct action, Officer McFadden approached the 3 men, identified himself as a police officer, and asked for their names. At this point, his knowledge was confined to what he had observed. He was not acquainted with any of the 3 men by name or by sight, and he had received no information concerning them from any other source. When the men mumbled something in response to his inquiries, Officer McFadden grabbed Petitioner Terry, spun him around so that they were facing each other, with Terry between McFadden and the others, and patted down the outside of his clothing. In the left breast pocket of Terry's overcoat, Officer McFadden felt a pistol. He reached inside the overcoat pocket, but was unable to remove the gun. At this point, keeping Terry between himself and the others, the officer ordered all 3 men to enter Zucker's store. As they went in, he removed Terry's overcoat completely, removed a .38 caliber revolver from the pocket, and ordered all 3 men to face the wall with their hands raised. Officer McFadden proceeded to pat down the outer clothing of Chilton and the third man, Katz. He discovered another revolver in the outer pocket of Chilton's overcoat, but no weapons were found on Katz. The officer testified that he only patted the men down to see whether they had weapons, that he did not put his hands beneath the outer garments of either Terry or Chilton until he felt their guns. So far as appears from the record, he never placed his hands beneath Cat's outer garments. Officer McFadden seized Chilton's gun, asked the proprietor of the store to call a police wagon, and took all three men to the station, where Chilton and Terry were formally charged with carrying concealed weapons. On the motion to suppress the guns, the prosecution took the position that they had been seized following a search incident to a lawful arrest. The trial court rejected this theory, stating that it would be stretching the facts beyond reasonable comprehension to find that Officer McFadden had had probable cause to arrest the men before he patted them down for weapons. However, the court denied the defendant's motion on the ground that Officer McFadden, on the basis of his experience, had reasonable cause to believe that the defendants were conducting themselves suspiciously and some interrogation should be made of their action. That's the state's interpretation of what's required for suspicion. Purely for his own protection, the court held the officer had the right to pat down the outer clothing of these men who he had reasonable cause to believe might be armed. The court distinguished between an investigatory stop and an arrest, and between a frisk at the outer clothing for weapons and a full-blown search for evidence of crime. Keep in mind, this is just the state of Ohio courts and what their interpretation is at this point. The frisk it held was essential to the proper performance of the officer's investigatory duties, for without the answer to the police officer, maybe a bullet and a loaded pistol discovered during the frisk is admissible. After the court denied their motion to suppress, Chilton and Terry waived jury trial and pleaded not guilty. The court adjudged them guilty, and the Court of Appeals for the 8th Judicial District, Cuyahoga County, affirmed State v. Terry, and then it gives the reference. So, the Supreme Court of Ohio dismissed their appeal on the ground that no substantial constitutional question was involved. We granted cert. Excuse me. It's important to note that the Supreme Court grants cert very, very seldom. Most of the time, when you're looking at the case history, the last word you see is cert denied. The Supreme Court turns down review of most cases. So we granted cert, and there's the reference to determine whether the admission of the revolvers and evidence violated petitioners' rights under the Fourth Amendment made applicable to the states by the 14th Amendment. We affirm the conviction. So there's your answer. The conviction is affirmed, but there's a whole lot of analysis to come. Okay, let's take a look at Chief Justice Warren's analysis in this case. In Section 1, the Fourth Amendment provides that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. That is essentially the Fourth Amendment. This inestimable right of personal security belongs as much to the citizen on the streets of our cities as to the homeowner closeted in his study to dispose of his secret affairs. For as this court has always recognized, no right is held more sacred or is more carefully guarded by the common law than the right of every individual to the possession and control of his own person, free from all restraint or interference of others, unless by clear and unquestionable authority of law. So that's the floor, that's the foundation. We absolutely have a right not to be interfered with by our government unless there is some actual reasonable reason to do so. So just asking every person on the street you come across to identify themselves may seem like no small thing, but people have a right not to be interfered with by the police and by the government. And so, back to the case, we have recently held that the Fourth Amendment protects people, not places, and wherever any individual may harbor a reasonable expectation of privacy. Of course, the specific content and incidence of this right must be shaped by the context in which it is asserted. For what the Constitution forbids is not all searches and seizures, but unreasonable searches and seizures. Unquestionably, petitioner was entitled to the protection of the Fourth Amendment as he walked down the street in Cleveland. The question is whether, in all the circumstances of this on-the-street encounter, his right to personal security was violated by any unreasonable search and seizure. We would be less than candid if we did not acknowledge that this question thrusts to the fore difficult and troublesome issues regarding a sensitive area of police activity. issues which have never before been squarely presented to this court. Reflective of the tensions involved are the practical and constitutional arguments pressed with great vigor on both sides of the public debate over the power of the police to stop and frisk, as it is sometimes euphemistically termed, suspicious persons. On the one hand, it is frequently argued that in dealing with rapidly unfolding and often dangerous situations on city streets, the police are in need of an escalating set of flexible responses, graduated in relation to the amount of information they possess. For this purpose, it is urged that distinctions should be made between a stop and an arrest, or a seizure of a person, and between a frisk and a search. Thus, it is argued the police should be allowed to stop a person and detain him briefly for questioning upon suspicion that he may be connected with criminal activity. Again, not just a suspicion, not just acting suspiciously, but may be connected with criminal activity. There has to be an actual crime that they can articulate. Upon suspicion that the person may be armed, the person should have the power to frisk him for weapons. And again, the suspicion that he may be armed, not just for police safety. The police should have the power to frisk him for weapons. If the stop and the frisk give rise to probable cause to believe that the suspect has committed a crime, then the police should be empowered to make a formal arrest and a full incident search of the person. This scheme is justified in part upon the notion that a stop and frisk amount to a mere inconvenience and petty indignity, which can properly be imposed upon the citizen in the interest of effective law enforcement on the basis of a police officer's suspicion. On the other side of the argument is that the authority of the police must be strictly circumscribed by the law of arrest and search as it is developed to date in the traditional jurisprudence of the Fourth Amendment. It is continued with some force that there is not and cannot be a variety of police activity which does not depend solely upon the voluntary cooperation of the citizen, and yet which stops short of an arrest based upon probable cause to make such an arrest. The heart of the Fourth Amendment, the argument runs, is a severe requirement of specific justification for any intrusion upon protected personal security, coupled with a highly developed system of judicial controls to enforce upon the agents of the state that commands of the Constitution. Acquiescence by the courts in the compulsion inherent in the field interrogation practices at issue here, it is urged, would continue an abdication of judicial control over and indeed an encouragement of substantial interference with liberty and personal security by police officers whose judgment is necessarily colored by their primary involvement in the often competitive enterprise of ferreting out crime. This, it is argued, can only serve to exacerbate police community tensions in the crowded centers of our nation's cities. In this context, we approach the issues in this case mindful of the limitations of the judicial function in controlling the myriad daily situations in which policemen and citizens confront each other on the street. The state has characterized the issue here as the right of a police officer to make an on-the-street stop, interrogate, and pat down for weapons, known in street vernacular as stop and frisk. But this is only partly accurate, for the issue is not the abstract propriety of the police conduct, but the admissibility against petitioner of the evidence uncovered by the search and seizure. Ever since its inception, the rule excluding evidence seized in violation of the Fourth Amendment has been recognized as a principal mode of discouraging lawless police conduct. Thus its major thrust is a deterrent one, and experience has taught that it is the only effective deterrent to police misconduct in the criminal context, and that without it, the constitutional guarantee against unreasonable searches and seizures would be mere form of words. The rule also serves another vital function, the imperative of judicial integrity. Courts which sit under our Constitution cannot and will not be made party to lawless invasions of the constitutional rights of citizens by permitting unhindered governmental use of the fruits of such invasions. Thus, in our system, evidentiary rulings provide the context in which the judicial process of inclusion and exclusion approves some conduct as comporting with constitutional guarantees and disapproves other actions by state agents. A rule admitting evidence in a criminal trial, we recognize, has the necessary effect of legitimizing the conduct which produced the evidence, while an application of the exclusionary rule withholds the constitutional imprimatur. So this is, I'm not going to read the rest of this on the exclusionary rule. That's an established rule. It's relevant to this case, but it's not one of the facts at issue in this case. If McFadden was reasonable in what he did, the evidence is in. If he wasn't, the evidence is out under the exclusionary rule. But I'm gonna skip over this section of the analysis. And so we go to section 2 of the analysis. Our first task is to establish at what point in this encounter the Fourth Amendment becomes relevant. That is, we must decide whether and when Officer McFadden seized Terry and whether and when he conducted a search. There is some suggestion in the use of the terms, such as stop and frisk, that such police conduct is outside the purview of the Fourth Amendment because neither action rises to the level of search or seizure within the meaning of the Constitution. And this is important. We emphatically reject this notion. It is quite plain that the Fourth Amendment governs seizures of the person which do not eventuate in a trip to the station house and prosecution for crime, arrest in traditional terminology. It must be recognized that whenever a police officer accosts an individual and restrains his freedom to walk away, he has seized that person. And it is nothing less than sheer torture of the English language to suggest that a careful exploration of the outer surfaces of a person's clothing all over his or her body in an attempt to find weapons is not a search. Moreover, it is simply fantastic to urge that such a procedure performed in public by a policeman while the citizen stands helpless, perhaps facing a wall with his hands raised, is a petty indignity. It is a serious intrusion upon the sanctity of the person which may inflict great indignity and arouse strong resentment, and it is not to be undertaken lightly. I think that's one of the most important paragraphs in this case. It's something that I think that the police should maybe give a little more thought to and consideration to what country we're living in, while balancing that, of course, against their officer safety. So the danger in the logic which proceeds upon distinctions between a stop and an arrest or seizure of the person and between a frisk and a search is twofold. It seeks to isolate from constitutional scrutiny the initial stages of the contact between the policeman and the citizen. And by suggesting a rigid all-or-nothing model of justification and regulation under the amendment, it obscures the utility of limitations upon the scope as well as the initiation of police action as a means of constitutional regulation. This court has held in the past that a search which is reasonable at its inception may violate the Fourth Amendment by virtue of its intolerable intensity and scope. The scope of the search must be strictly tied to and justified by the circumstances which rendered its initiation permissible. The distinctions of classical stop and frisk theory that thus serve to divert attention from the central inquiry under the Fourth Amendment, the reasonableness in all the circumstances of the particular governmental invasion of a citizen's personal security. Search and seizure are not talismans. We therefore reject the notion that the Fourth Amendment does not come into play at all as a limitation upon police conduct if the officer stopped short of something called a technical arrest or a full-blown search. In this case, there can be no question then that Officer McFadden seized petitioner and subjected him to a search when he took hold of him and patted down the outer surface of his clothing. We must decide whether at that point it was reasonable for Officer McFadden to have interfered with petitioner's personal security as he did. And in determining whether the seizure and search were unreasonable, our inquiry is a dual one: whether the officer's action was justified at its inception, and whether it was reasonably related in scope to the circumstances which justified the interference in the first place. So the court has found that the pat down, stopping him on the street, that's not an arrest, but that falls under the Fourth Amendment in any event. And so now we have to decide, well, in that case, is it reasonable in the circumstances? So Section 3 in this case, if this case involved police conduct subject to the warrant clause of the Fourth Amendment, we would have to ascertain whether probable cause existed, key phrase, probable cause as opposed to reasonable suspicion, existed to justify the search and seizure which took place. However, that is not the case. We do not retreat from our holdings that the police must, whenever practicable, obtain advanced judicial approval of searches and seizures through the warrant process, or that in warrant procedure, or that in most instances, failure to comply with the warrant requirements can only be excused by exigent circumstances. But we deal here with an entire rubric of police conduct, necessarily swift action predicated upon the on-the-spot observations of the officer on the beat, which historically has not been, and as a practical matter could not be, subjected to the warrant procedure. Instead, the conduct involved in this case must be tested by the Fourth Amendment's general prescription against unreasonable searches and seizures. So officer safety, those kind of circumstances are a factor to be considered, the court is recognizing. Nonetheless, the notions which underlie both the warrant procedure and the requirements of probable cause remain fully relevant in this context. In order to assess the reasonableness of Officer McFadden's conduct as a general proposition, it is necessary first to focus upon the governmental interest which allegedly justifies official intrusion upon the constitutionally protected interests of the private citizen. For there is no ready test for determining reasonableness other than by balancing the need to search or seize against the invasion which the search or seizure entails. And in justifying the particular intrusion, the police officer must be able to point to specific and articulable facts which, taken together with rational inferences from those facts, reasonably warrant that intrusion. Again, a very important sentence. The police officer must be able to point to specific and articulable facts which, taken together with rational inferences from those facts, reasonably warrant that intrusion. The scheme of the Fourth Amendment becomes meaningful only when it is assured that at some point the conduct of those charged with enforcing the laws can be subjected to the more detached, neutral scrutiny of a judge who must evaluate the reasonableness of a particular search or seizure in light of the particular circumstances. In making that assessment, it is imperative that the facts be judged against an objective standard. Would the facts available to the officer at the moment of the seizure of the search warrant a man of reasonable caution in the belief that the action taken was appropriate? So, objective, subjective, objective analysis there. Anything less would invite intrusions upon constitutionally guaranteed rights based on nothing more substantial than inarticulate hunches, a result this court has consistently refused to sanction. And simple good faith on the part of the arresting officer is not enough. If subjective good faith alone were the test, the protections of the Fourth Amendment would evaporate and the people would be secure in their persons, houses, papers, and effects only in the discretion of the police. Applying these principles to this case, we consider first the nature and extent of the governmental interests involved. One general interest is, of course, that of effective crime prevention and detection. It is this interest which underlies the recognition that a police officer may, in appropriate circumstances and in an appropriate manner, approach a person for purposes of investigating possibly criminal behavior, even though there is no probable cause to make an arrest. It was this legitimate investigative function Officer McFadden was discharging when he decided to approach Petitioner and his companions. He had observed Terry, Chilton, and Katz go through a series of acts, each of them perhaps innocent in itself, but which taken together warranted further investigation. There is nothing unusual in two men standing together on a street corner, perhaps waiting for someone, nor is there anything suspicious about people in such circumstances strolling up and down the street singly or in pairs. Store windows, moreover, are made to be looked in, but the story in quite different. I think that should say the story is quite different. Whereas here, two men hover about a street corner for an extended period of time, at the end of which it becomes apparent that they were not waiting for anything, anyone, or anything. Where these men pace alternately along an identical route, pausing to stare in the same store window roughly 24 times, where each completion of this route is followed immediately by a conference between the two men on the corner, where they are joined in one of these conferences by a third man who leaves swiftly, and where the two men finally follow the third and rejoin him a couple of blocks away. It would have been poor police work indeed for an officer of 30 years' experience in the detection of thievery from stores in the same neighborhood to have failed to investigate this behavior further. So critical to Terryville, Ohio. McFadden actually saw things that gave him a reasonable, articulable suspicion that crime was afoot. And that's critical here. You can't do what he did without that. The crux of this case, however, is not the propriety of Officer McFadden's taking steps to investigate petitioner's suspicious behavior, but rather whether there was justification for McFadden's invasion of Terry's personal security by searching him for weapons in the course of that investigation. So now we're getting specifically to the pat-down. We are now concerned with more than the governmental interest in investigating crime. In addition, there is the more immediate interest of the police officer in taking steps to assure himself that the person with whom he is dealing is not armed with a weapon that could unexpectedly and fatally be used against him. Certainly, it would be unreasonable to require the police officers take unnecessary risks in the performance of their duties. American criminals have a long tradition of armed violence, and every year in this country, many law enforcement officers are killed in the line of duty, and thousands more are wounded. Virtually all of these deaths and a substantial portion of the injuries are inflicted with guns and knives. In view of these facts, we cannot blind ourselves to the need of law enforcement officers to protect themselves and other prospective victims of violence in situations where they may lack probable cause for an arrest. When an officer is justified in believing that the individual whose suspicious behavior he is investigating at close range is armed and presently dangerous to the officer or others, it would appear to be clearly unreasonable to deny the officer the power to take necessary measures to determine whether the person is in fact carrying a weapon and to neutralize the threat of physical harm. Key phrases in here. Investigating at close range is armed. Just when an officer is justified in believing that the individual whose suspicious behavior he is investigating at close range is armed. He actually believes he is armed. He's not just patting him down just as part of the routine. So we must still consider, however, the nature and the quality of the intrusion on individual rights, which must be accepted if police officers are to be conceded the right to search for weapons in situations where probable cause to arrest for crime is lacking. Even a limited search of the outer clothing for weapons constitutes a severe, though brief, intrusion upon cherished personal security, and it must surely be an annoying, frightening, and perhaps humiliating experience. Petitioner contends that such an intrusion is permissible only incident to a lawful arrest, either for a crime involving the possession of weapons or for a crime the commission of which led the officer to investigate in the first place. However, this argument must be closely examined. Petitioner does not argue that a police officer should refrain from making any investigation of suspicious circumstances until such time as he has probable cause to make an arrest. Nor does he deny that police officers, in properly discharging their investigative function, may find themselves confronting persons who may well be armed and dangerous. Moreover, he does not say that an officer is always unjustified in searching a suspect to discover weapons. Rather, he says it is unreasonable for the policeman to take that step until such time as the situation evolves to a point where there is probable cause to make an arrest. When that point has been reached, petitioner would concede the officer's right to conduct a search of the suspect for weapons, fruits or instrumentalities of the crime, or mere evidence incident to the arrest. There are two weaknesses in this line of reasoning, however. First, it fails to take account of traditional limitations upon the scope of searches, and thus recognizes no distinction in purpose, character, and extent between a search incident to an arrest and a limited search for weapons. The former, although justified in part by the acknowledged necessity to protect the arresting officer from assault with a concealed weapon, is also justified on the grounds and can therefore involve a relatively extensive explanation of the person. A search for weapons in the absence of probable cause to arrest, however, must, like any other search, be strictly circumscribed by the exigencies which justify its initiation. Thus, it must be limited to that which is necessary for the discovery of weapons which might be used to harm the officer or others nearby, and may realistically be characterized as something less than a full search, even though it remains a serious intrusion. A second and related objection to petitioner's argument is that it assumes that the law of arrest has already worked out the balance between the particular interests involved here. The neutralization of danger to the policeman in the investigative circumstance and the sanctity of the individual. But this is not so. An arrest is a wholly different kind of intrusion upon individual freedom from a limited search for weapons, and the interests each is designed to serve are likewise quite different. An arrest is the initial stage of a criminal prosecution. It is intended to vindicate society's interest in having its laws obeyed, and it is inevitably accompanied by future interference with the individual's freedom of movement, whether or not trial or conviction ultimately follows. The protective search for weapons, on the other hand, constitutes a brief, though far from inconsiderable, intrusion upon the sanctity of the person. It does not follow that because an officer may lawfully arrest a person only when he is apprised of facts sufficient to warrant a belief that the person has committed or is committing a crime, the officer is equally unjustified, absent that kind of evidence, in making any intrusions short of an arrest. Moreover, a perfectly reasonable apprehension of danger may arise long before the officer is possessed of adequate information to justify taking a person into custody for the purpose of prosecuting him for a crime. Petitioners' reliance on cases which have worked out standards of reasonableness with regard to seizures constituting arrests and searches incident thereto is thus misplaced. It assumes that the interests sought to be vindicated and the invasions of personal security may be equated in the two cases, and thereby ignores a vital aspect of the analysis of the reasonableness of particular types of conduct under the Fourth Amendment. So the Supreme Court, Warren is finding this middle ground where, it's something less than an arrest, but there is reasonable intrusion into the personal sanctity, the personal privacy of the individual. Our evaluation of the proper balance that has been struck in this type of case leads us to conclude that there must be a narrowly drawn authority to permit a reasonable search for weapons for the protection of the police officer. Again, key phrase here, where he has reason to believe that he is dealing with an armed and dangerous individual, regardless of whether he has probable cause to arrest the individual for a crime. So something less than the probable cause standard, but he's still got to have a reasonable belief that the person is armed and dangerous. The officer need not be absolutely certain that the individual is armed. The issue is whether a reasonably prudent man in the circumstances, person we would say, would be warranted in the belief that his safety or that of others was in danger. And in determining whether the officer acted reasonably in such circumstances, due weight must be given to his inchoate, however you like to pronounce it, an unparticularized suspicion or hunch, but to the specific reasonable inferences which he's entitled to draw from the facts in light of the experience. So now we bring it down to, how do we analyze what McFadden did? So we must now examine the conduct of Officer McFadden in this case to determine whether his search and seizure of petitioner was reasonable, both at their inception and as conducted. He had observed Terry together with Chilton and another man acting in a manner he took to be prefaced to a stick-up. We think on the facts and circumstances Officer McFadden detailed before the trial judge, a reasonably prudent man would have been warranted in believing petitioner was armed and thus presented a threat to the officer's safety while he was investigating his suspicious behavior. There you go. That was reasonable to believe that they were armed. The actions of Terry and Chilton were consistent with McFadden's hypothesis that these men were contemplating a daylight robbery, which is reasonable to assume would be likely to involve the use of weapons, and nothing in their conduct from the time he first noticed them until the time he confronted them and identified himself as a police officer gave him sufficient reason to negate that hypothesis. Although the trio had departed the original scene, there was nothing to indicate abandonment of an intent to commit a robbery at some point. Thus, when Officer McFadden approached the three men gathered before the display window at Zucker's store, he had observed enough to make it quite reasonable to fear that they were armed, and nothing in their response to his hailing them, identifying himself as a police officer, and asking their names served to dispel that reasonable belief. We cannot say his decision at that point to seize Terry and pat his clothing for weapons was a product of a volatile or inventive imagination, or was undertaken simply as an act of harassment. The record evidences the tempered act of a policeman who, in the course of an investigation, had to make a quick decision as to how to protect himself and others from possible danger, and took limited steps to do so. So in Terry v. Ohio, McFadden acted reasonably in believing that Terry and his friends were actually armed and dangerous. The manner in which the seizure and search were conducted is, of course, as vital a part of the inquiry as whether they were warranted at all. The Fourth Amendment precedes as much by limitations upon the scope of governmental action as by imposing preconditions upon its initiation. The entire deterrent purpose of the rule excluding evidence seized in violation of the Fourth Amendment rests on the assumption that limitations upon the fruit to be gathered tend to limit the quest itself. Thus, evidence may not be introduced if it was discovered by means of a seizure and search which were not reasonably related in scope to the justification for their initiation. We need not develop at length in this case, however, the limitations which the Fourth Amendment places upon the protective seizure and search for weapons. These limitations will have to be developed in the concrete factual circumstances of individual cases. Suffice it to note that such a search, unlike a search without a warrant incident to a lawful arrest, is not justified by any need to prevent the disappearance or destruction of evidence of crime. The sole justification of the search in the present situation is the protection of the police officer. Officer safety, you hear that over and over and over, and others nearby, and it must therefore be confined in scope to an intrusion reasonably designed to discover guns, knives, clubs, or other hidden instruments for the assault of the police officer. The scope of the search in this case presents no serious problem in light of these standards. Officer McFadden patted down the outer clothing of petitioner and his two companions. He did not place his hands in their pockets or under the outer surface of the garments until he had felt weapons, and then he merely reached for and removed the guns. He never did invade Cat's person beyond the outer surface of his clothes, since he discovered nothing in his pat-down which might have been a weapon. Officer McFadden confined his search strictly to what was minimally necessary to learn whether the men were armed, and to disarm them once he discovered the weapons. He did not conduct a general exploratory search for whatever evidence of criminal activity he might find. So this is, again, the extent of the search. He patted them down, he felt weapons, and then he reached inside their clothing. Otherwise, he didn't in the case of Katz, and Warren is finding that was reasonable behavior. Okay, so wrapping up the Warren piece of the opinion, we conclude that the revolver seized from Terry was properly admitted and evidence against him. At the time he seized petitioner and searched for weapons, Officer McFadden had reasonable grounds to believe that petitioner was armed and dangerous, once again, and it was necessary for the protection of himself and others to take swift measures to discover the true facts and neutralize the threat of harm if it materialized. The policeman carefully restricted his search to what was appropriate to the discovery of the particular items which he sought. Each case of this sort will, of course, have to be decided on its own facts. We merely hold today that where a police officer observes unusual conduct which leads him reasonably to conclude, in light of his experience, that criminal activity may be afoot, and that the person with whom he is dealing may be armed and presently dangerous, where in the course of investigating this behavior, he identifies himself as a policeman and makes reasonable inquiries, where nothing in the initial stages of the encounter serves to dispel his reasonable fear of his own or other safety, he is entitled, for the protection of himself and others in the area to conduct a carefully limited search of the outer clothing of such persons in an attempt to discover weapons which might be used to assault him. Such a search is a reasonable search under the Fourth Amendment, and any weapons seized may properly be introduced in evidence against the person from whom they were taken. So that's the opinion of the court. Again, an 8-1 decision. I have not studied the case history here. I don't know if there have been Supreme Court cases that have tweaked this interpretation or changed it in some way. I don't believe so. I believe this is still the standard. The police officer has to reasonably believe crime is afoot, not just think the behavior is suspicious. And he must reasonably believe that the person that he's dealing with is in fact armed, not just, maybe he could be. But again, I have not looked at later case law on this. Okay, let's take a look at what some of the other justices said. And this is common. You'll have a majority opinion, but there'll be something about it that some other justice who joined in that decision wants to say about the case. We have a couple of those, and then it's an 8-1 decision, so we clearly have one dissenting opinion also that we'll take a look at. I'm not going to go through the two consents. Basically, we've got Justice Black concurs in the judgment of the opinion, except where the opinion quotes from and relies upon this court's opinion in Katz. So Justice Black, Hugo Black, does not like the Katz decision. He really doesn't have any issue with this decision. Justice Harlan, who was also appointed by Eisenhower and is generally considered to be a part of the conservative wing of the court at the time, concurs in the opinion. I said concurrence is what I meant. He concurs in this decision. It seems that his one point is to say that you just need a reason to be stopping this person if you think they're involved in a serious crime. You don't have to actually believe they are armed in order to pat them down. That you should be able to do that immediately in these circumstances for officer safety. And I'm sure a lot of the public and certainly the police would agree with that. The other concurring opinion is Byron Whizzer White. He was appointed by Kennedy and is a Democrat and generally more progressive, but also a bit of a literalist or a strict interpretationist is the term I'm looking for. But he basically has the same opinion as well. He thinks that there really should not be any reason to have to you believe that the person you're talking to is armed. That you should, under those circumstances, if it's a legitimate temporary detention, you should be allowed to frisk the person. So then we get to Justice William O. Douglas dissenting. He was the one vote against. Justice Douglas was appointed by Roosevelt. Actually, he was appointed at 40 years old, very young for a Supreme Court justice, and was on the court for a very long time. Had a little bit of a reputation for not really basing his opinions on case law precedent, that type of thing, but sometimes just how did he feel about a case. So let's take a look at what he had to say in his dissent in this case. So he says, I agree the petitioner was seized within the meaning of the Fourth Amendment. I also agree that frisking petitioner and his companions for guns was a search. But it is a mystery how that search and that seizure can be constitutional by Fourth Amendment standards unless there was probable cause to believe that A, a crime had been committed, and B, a crime was in the process of being committed, or two, a crime was in the process of being committed, or a crime was about to be committed. The opinion of the court, well, let me back up. So he's saying basically, forget all this in-between stuff. It's either probable cause or it's not. And if it's not probable cause, you're violating the Fourth Amendment. That's his opinion in this case. The opinion of the court disclaims the existence of probable cause. If loitering were an issue that was the offense charge, there would be probable cause shown. But the crime here is carrying concealed weapons, and there is no basis for concluding that the officer had probable cause for believing that a crime was being committed. Had a warrant been sought, a magistrate would therefore have been unauthorized to issue one, for he can act only if there is a showing of probable cause. We hold today that the police have greater authority to make a seizure and conduct a search than a judge has to authorize such action. We have said precisely the opposite over and over again. In other words, police officers up to today have been permitted to effect arrests or searches without warrants only when the facts within their personal knowledge would satisfy the constitutional standard of probable cause. At the time of their seizure without a warrant, they must possess facts concerning the person arrested that would have satisfied a magistrate that probable cause was indeed present. The term probable cause rings a bell of certainty that is not sounded by phrases such as reasonable suspicion, that lower standard, reasonable suspicion. Moreover, the meaning of probable cause is deeply embedded in our constitutional history. The requirement of probable cause has roots that are deep in our history. The general warrant in which the name of the person to be arrested was left blank, and the writs of assistance against which James Otis inveighed both perpetuated the oppressive practice of allowing the police to arrest and search on suspicion. Police control took the place of judicial control, since no showing of probable cause before a magistrate was required. That philosophy, rebelling against these practices, later was reflected in the Fourth Amendment. And as the early American decisions, both before and immediately after its adoption, show, common rumor or report, suspicion, or even reason to suspect was not adequate to support a warrant for arrest. and that principle has survived to this day. It is important, we think, that this requirement of probable cause be strictly enforced, for the standard set by the Constitution protects both the officer and the citizen. If the officer acts with probable cause, he is protected even though it turns out that the citizen is innocent. And while a search without a warrant is within limits permissible if incident to a lawful arrest, if an arrest without a warrant is to support an incidental search, it must be made with probable cause. This immunity of officers cannot fairly be enlarged without jeopardizing the privacy or security of the citizen. And this is Douglas quoting some older case law, in general, saying, if we're not going to let a judge issue a warrant without probable cause, why in the world would we let the police act in that way? Again, this is Douglas's view of it. The infringement of personal liberty of any seizure of a person can only be reasonable under the Fourth Amendment if we require the police to possess probable cause before they seize him. That's the crux of his argument. Only that line draws a meaningful distinction between an officer's mere inkling and the presence of facts within the officer's personal knowledge, which would convince a reasonable man that the person seized is committing, or is about to commit a particular crime. In dealing with probable cause, as the very name implies, we deal with probabilities. These are not technical. They are the factual and practical considerations of everyday life on which reasonable and prudent men, not legal technicians, act. To give the police greater power than a magistrate is to take a long step down the totalitarian path. Perhaps such a step is desirable to cope with modern forms of lawlessness, but if it is taken, it should be the deliberate choice of the people through a constitutional amendment. Until the Fourth Amendment, which is closely allied with the Fifth, is rewritten, the person and the effects of the individual are beyond the reach of all government agencies until there are reasonable grounds to believe probable cause that a criminal venture has been launched or is about to be launched. There have been powerful hydraulic pressures throughout our history that bear heavily on the court to water down constitutional guarantees and give the police the upper hand. That hydraulic pressure has probably never been greater than it is today. Yet if the individual is no longer to be sovereign, if the police can pick him up whenever they do not like the cut of his jib, if they can seize and search him in their discretion, we enter a new regime. The decision to enter it should be made only after a full debate by the people of this country. And that's the end of the dissent. And then the footnotes follow. I would encourage people to read the footnotes. And the footnotes in legal writing and in court opinions have just a ton of information, other case references and clarifications. But that's Terry v. Ohio. That is why police officers have a right to pat down people under this case that they suspect of actually being armed. Douglas makes his strong argument, but he lost 8-1. Everyone else on the court disagreed with him, and there were certainly, including Warren and Brennan, other progressives on the court. But that's what Terry v. Ohio stands for. Those are the facts behind it and the analysis of the case. I just think that's helpful if people are going to be referencing the case to actually have a good idea of what the actual case does say. So that was the point of this. I hope that has been helpful. If you like that, like I said, give me a like, subscribe. I'm going to do multiple analyses of cases, U.S. Supreme Court cases in the areas of First, Second, Fourth, and Fifth Amendment jurisprudence. And I appreciate your hanging in there this long. I think this one was a little bit of a long one, but I appreciate it. And hopefully I will see you down the road on YouTube. Thank you.